Imagine this. A vast fortune tied up in mining rights. A relationship of, well, deep trust between friends that just unravels into this bitter, multi-decade legal battle. You've got secret share transfers hopping across international borders.
Yeah, and a courtroom saga that becomes this classic lesson in the unforgiving rules of procedure.
Exactly. And that's not fiction. It's a real-life story that became a landmark case down in Australia. And today, we're taking a deep dive into your source materials to untangle this fascinating, really complex dispute. At the very center of all this legal drama is a block of shares. Initially, they were valued at, what, $150,000 back in the late 1960s? Shares in a mining company called Southland Mining.
That's right.
And the mining rights themselves were in Fiji, owned by a businessman, Mr. Hari Akhil, and his company, Akhil Holdings. These shares were actually part of the payment for those rights. But who are they really for? And, what chain of events led them from a Swiss bank into this maze of international transfers? It's like they just vanished from the people who claimed they own them. Just try to imagine the immense stakes, the frustration, and, well, the sense of betrayal for Mr. Akhil and his family.
And this story, it goes far beyond just, chasing missing money. It's really a profound examination of fundamental legal principles, particularly how disputes are fought within the, let's say, strict confines of court rules.
Right.
It forces us to confront these crucial questions. What are the legal consequences when a trusted advisor is alleged to have acted improperly? I mean, how do the often technical rules of civil procedure, things like what you write down and where you write it down in your legal documents, how do they determine the outcome of a massive claim?
Yeah, the nitty-gritty details.
Exactly. And how can neglecting those seemingly minor details prove fatal, right? Even when the underlying facts seem to totally support your side. The case that encapsulates all of this, and the one we'll be dissecting today based on the documents you've shared, is Akhil Holdings Ltd v Banque Commerciale SA, MNLIQ. And, as legal scholars often point out, it's become a truly seminal authority in Australian civil procedure, especially for what it teaches us about the critical importance of pleadings and the specific requirements for alleging something as serious as fraud in court.
Okay, let's unpack this really layered story then, starting with the main characters who brought this whole drama to life across, well, multiple courtrooms. First up, we have Akhil Holdings Ltd. This was a Fijian company, mainly involved in mining manganese and controlled by Mr. Hari Akhil and his family. The sources describe Mr. Akhil himself as, highly experienced in the mining side of things. But importantly, not well-versed in company accounts. He placed significant reliance on his advisor, Mr. Messara. He even stated he was entirely controlled by Messara and his accountant when it came to the company's paperwork. He sort of saw himself as less sophisticated in business compared to Messara. Then there's Mr. Maurice Messara. He was the third respondent in the case. Messara was an accountant and advisor, and he apparently developed a very close business and personal relationship with Mr. Akhil over many years.
Yeah, that closeness is key.
He held a general power of attorney for Mr. Akhil for about a decade, 1964 to 1974. He was managing director of Southland Mining. Mining, the company involved in the purchase. He controlled another company called Deauville Nominees and was clearly very knowledgeable about Akhil's business. Justice Cohen, who heard the case first, described him as sophisticated.
And you can see the potential for, well, complicated dynamics right there, can't you? Messara is acting as Akhil's trusted advisor, handling his paperwork, holding his power of attorney. But at the same time, he's connected to the international bank where some shares end up. He controls the company that ultimately receives those shares from the bank, and he's the managing director of the company buying Akhil's main asset. It's this intricate web of relationships sitting right at the heart of the dispute. It's absolutely critical context to understand.
Okay, and our primary respondent was Banque Commerciale SA, a Swiss bank. This is where that significant block of shares from the sale initially landed. The bank later went into liquidation, which, adds another layer of complexity.
Oh, it does.
And the bank's position throughout this whole thing was that it did not hold a beneficial interest in the shares, only a registered one. The sources indicate Mr. Messara or his companies acted as the bank's agents in Australia. Then the second respondent was Deauville Nominees PDA Ltd. This company was controlled by Mr. Messara's family, is the entity that received the shares from the bank and became the registered owner for a while after they moved from Switzerland.
Got it.
We also need to quickly mention Southland Mining Ltd., the company actually acquiring Akhil's mining rights. As we noted, Mr. Messara was the managing director and closely tied to it. And Southland had a wholly owned subsidiary set up in Fiji called Manganex Ltd. That was the actual entity that purchased the mining rights from the Akhil interests. The payment, including those shares, was structured through Southland, the parent company.
Makes sense.
And finally, as the shares changed hands even further down the line, two other companies pop up in the transfer documents. Établissement Dormit, called ED, and Établissement de Placement et Rapport, or EPR. They got the shares from Deauville in later transfers.
So you have Mr. Akhil, who explicitly says he relied heavily on his advisor, Mr. Messara. And Mr. Messara is wearing multiple hats, deeply connected to the acquiring company, the company that ends up holding the shares, and the bank where they first arrive. This isn't just a simple business transaction. It's a story steeped in a close personal relationship and, frankly, a tangle of potential conflicts right from the get-go.
All right, let's trace how this whole thing kicked off the sale of the mine and the first appearance of those, well, mystery shares. What were the steps in that initial deal?
Okay, so negotiations started around 1968. Akhil Holdings and Mr. Akhil were looking to sell their Fijian mining rights. The agreed purchase price was $750,000 Australian.
A fair bit back then.
Definitely. And this payment wasn't all cash. It was structured as $350,000 in cash and $400,000 worth of shares in Southland Mining. An initial option agreement from July 1968 made it pretty clear. These shares were supposed to be issued directly to the vendors, meaning Akhil and Akhil Holdings.
Okay, straightforward enough so far.
Yeah.
But here's where it starts to get complicated, and where that Swiss bank confusingly enters the picture. There's this deed, right? Dated August 1st, 1968. Akhil and Akhil Holdings were parties, and the bank was named as a transferee.
Exactly. And this deed is absolutely central to understanding the early ambiguity. It stated that Akhil and Akhil Holdings agreed to procure, basically, arrange for shares with a par value of $150,000, which was exactly 20% of the total consideration, to be issued or transferred to the bank.
To the bank, why?
Well, and here's the kicker. Recital B in this deed contained a statement that caused a lot of debate later. It said that, in pursuance of arrangements previously made the transferee, the bank shall be entitled to receive this 20% chunk of the consideration.
Entitled to receive. That's the bit the sources call enigmatic, isn't it?
Yeah.
Why on earth would a bank in Switzerland be entitled to a slice of the payment for Akhil's mining assets?
It's the million-dollar question, or perhaps the $150,000 question back then, and it looms over the case, especially when you consider Akhil's later argument that the bank held no beneficial interest at all. Mr. Akhil testified that Mr. Messara advised him to arrange for the shares to go to the bank, maybe for tax planning or foreign exchange control reasons.
Okay, that makes a bit more sense, potentially.
Potentially. Akhil also claimed Messara told him this August 1968 deed would be automatically canceled when the earlier option agreement was superseded. However, the trial judge, Justice Cohen, he found that the August deed actually remained in force and the parties acted as if it did. This early puzzling statement about the bank's entitlement is a detail that really echoes later when the courts are scrutinizing all the documents.
So what actually happened when the shares were formally allotted? This was December 68, January 69.
Right. So a new option agreement was finalized with Manganix, the Fijian subsidiary, in December 1968. The very next day, Akhil Holdings and Mr. Akhil executed a direction to Manganix and Southland about how the share payment should happen. This direction confirmed the total $750,000 consideration was being paid to Akhil Holdings, minus a tiny adjustment. Akhil Holdings then formally applied for the $400,000 worth of Southland shares. That was 1.6 million shares at 25 cents each. And here's the absolutely critical part of that application. Their application directed the companies to issue shares to the par value of $250,000 to Akhil Holdings and to a par value of $150,000 to Banque Commerciale SA.
So part of Akhil's own payment for selling their assets was explicitly directed to go to a Swiss bank. But the direction also said they were allotted to the bank as nominees. That seems important.
Hugely important. That phrase, as nominees, becomes critical. Mr. Akhil's testimony at trial, which remember wasn't contradicted because Messara didn't give evidence, was that this specific direction came from Messara's advice.
Messara again.
Yes, and even the bank's own application form sent later described the shares as being received as nominees. There was just no indication in that original allotment direction that the bank was receiving the shares for itself beneficially. It pointed towards them holding it for someone else.
And then there was a share split later.
Yes. In April 1970, the Southland shares were split. They exchanged 5 10-cent shares for every 2 25-cent shares. This turned Akhil Holdings' original 1 million shares into 2.5 million, and the bank's 600,000 25-cent shares became 1.5 million 10-cent shares. And these 1.5 million shares became known as the Geneva shares.
Okay, so now we move from the, let's say, complicated setup to the alleged core of the wrongdoing. The shares supposedly just vanished from the bank.
This is where the alleged breach of trust really happens, according to Akhil's claim. The sources detail these crucial transfers. In June 1970, the bank sold a small parcel, just 25,000 shares. Then, in November 1970, the remaining 1,475,000 shares were transferred from the bank to Deauville Nominees. Remember, that's Mr. Messara's family company.
Messara's company again. And Akhil knew about this.
Mr. Akhil claimed, and Justice Cohen at the trial accepted this evidence, that this transfer happened completely without Akhil Holdings' notice or knowledge.
Wow. So the shares moved from the bank to Messara's company, allegedly without the person who says they're the real owner knowing anything about it. What happened when this transfer was registered? Did anyone notice?
Oh, yes. When the transfer was being processed in December 1970, the Stamp Duty's office flagged it. They wanted to understand the beneficial ownership who really owned these shares. They asked for statutory declarations from both the bank and Deauville confirming who the bank had held the shares for and who Deauville would now be holding them for.
Okay, so the authorities are asking questions. How did Messara's company, Deauville, respond?
In January 1971, Mr. Messara, signing as managing director of Deauville, sent a letter back to the Stamp Duty's office. It stated the bank had held the shares for non-resident accounts, that the portfolio management had shifted to EPR in Liechtenstein, and that EPR had requested the transfer to Deauville on their behalf.
On their behalf.
Exactly. And here's the absolutely critical representation made in that letter. It claimed there was no change in ownerships, but only a change of portfolio management, and that actually disclosing the beneficial owners was forbidden by Swiss law. Now, this is fascinating, isn't it? Because it's a very clear statement from Messara's company dealing with shares that originated as part of Akhil's payment, representing to a government authority that the shares were not beneficially owned by the bank or by Deauville. They were being held for others.
Right.
The Stamp Duty's office then specifically asked Deauville for confirmation that there was no change in beneficial ownership and that Deauville was only a trustee for the beneficial owners in place of Banque Commerciale SA. The sources indicate Deauville provided these confirmations.
So Deauville basically confirmed they were just stepping into the bank's shoes as trustee. Then the shares were transferred again.
Yes. Subsequent transfers happened in 1973, 1974, and 1976. Deauville transferred shares to ED and then to EPR. And the transfer forms themselves seemed to reinforce this trustee idea. They stated the consideration was either nominal or nil, which is consistent with the shares just moving between nominees or trustees, not being actually sold to a new beneficial owner.
Okay.
And crucially, according to Mr. Akhil's evidence, which Justice Cohen accepted, these transfers from the bank to Deauville and then from Deauville onwards all happened without Akhil Holdings' knowledge or consent. This forms the absolute basis of the breach of trust claim, that the entities holding the shares as trustee for Akhil transferred that property without the beneficiary's permission.
So the shares are gone, transferred multiple times, allegedly without the true owner knowing. Meanwhile, completely unrelated issues between Mr. Akhil and Mr. Messara and their companies are creating a whole separate firestorm.
That's right. Totally separate from the Geneva shares issue, Manganex, the Southland subsidiary, initiated a claim against Akhil Holdings. They alleged Akhil hadn't extracted enough manganese under the original agreement, and they wanted damages. Akhil disputed this entirely. This triggered what the sources call a bitter wrangle between the parties.
Sounds messy.
Very. And it severely damaged the personal and business trust that had existed for years between Mr. Akhil and Mr. Messara.
And this wrangle escalated into litigation.
It did. And that litigation was eventually settled by a comprehensive deed signed in mid-1977. Now, the parties to this deed were the Southland parties, which included Mr. Messara, and the Akhil parties, which included Mr. Hari Akhil and Akhil Holdings. But it's absolutely critical to note neither the bank nor Deauville were parties to this settlement deed.
Okay, Bank and Deauville aren't involved in settling this fight. But the Geneva shares did come up during these settlement discussions, didn't they?
They did, which makes everything even more complex later on. Clause 18 of the deed specifically references Mr. Akhil's continuing claim about the Geneva shares. Mr. Simos, who was Mr. Akhil's lawyer during these settlement talks, and later gave evidence in the main case, he suggested the shares be explicitly excluded from the settlement so Akhil could keep making inquiries.
Makes sense.
Then Mr. Hanley, who was Mr. Messara's lawyer at the time and also later a witness, produced the Southland share register showing the bank as the registered owner. And he passed on information directly from Mr. Messara.
What information?
Information that the bank held the shares beneficially for services provided to Messara.
Hang on. Mr. Messara's lawyer is now saying the bank held the shares beneficially for services rendered to Messara. But back in 1971, Messara himself, through his company Deauville, was telling the stamp duties office that Deauville was holding them as trustee for non-residents, not beneficially. Which story is it?
Exactly. The sources highlight this glaring inconsistency. This information from Messara via Handley during the settlement negotiations, claiming the bank held the shares beneficially for services, was completely at odds with the earlier representations to the stamp duties office, and actually what the bank's own position later revealed.
So what did the settlement deed actually do then?
The settlement deed contained a general release clause, Clause 7, releasing claims between the parties to the deed, so the Southland and Akhil parties. It essentially settled the manganese dispute. However, Clause 18 kept the Geneva shares issue alive, in a way, by including Messara's warranty about the power of attorney. A key legal question later became whether that general release in Clause 7 could potentially release Mr. Messara from liability as an accessory to a breach of trust regarding the Geneva shares.
Even though Akhil didn't know the shares had actually been transferred when he signed.
Precisely. Even though Akhil was completely unaware of the actual share transfers when he signed the deed, and because the bank and Deauville weren't parties to the deed, the claims against them were definitely not released by it.
Okay, so the unrelated fight is settled, but the search for the Geneva shares continues, now with renewed urgency.
Exactly. After that mid-1977 settlement, Mr. Akhil and his legal team really intensified their efforts to find the shares and figure out what had happened. His previous solicitors had written to the bank way back in December 1975, before the settlement, but the bank had claimed it couldn't even trace the name.
Convenient.
Then in August 1977, right after the settlement, Akhil's interest provided the bank with the actual Southland ledger card showing the bank as the registered owner. Proof.
How did the bank respond this time? Surely they had to acknowledge it now.
Initially, they still remained unforthcoming. Mr. Akhil changed solicitors again in late 1977, and this new firm energetically pursued the bank. They asked about the original allotment, all subsequent dealings, everything. The bank eventually just refused to provide information, citing Swiss secrecy laws.
The Swiss secrecy defense.
Classic move. The solicitors for Southland were also initially reluctant, apparently, but eventually, according to the sources, they reluctantly and belatedly produced the details of the transfers from the bank to Deauville and then from Deauville on to ED and EPR. Finally. And this was a critical breakthrough. It revealed the transfers from the bank to Deauville and onwards had actually happened before the 1977 settlement deed was even signed.
So Messara knew.
The Messara interests knew about these transfers when they were responding to earlier inquiries and throughout those settlement negotiations where the shares were discussed, yet the full picture wasn't revealed until much later, reluctantly and belatedly. This discovery is what finally triggered the formal lawsuit we're discussing.
And so the battle moved properly into the courtroom. Formal legal proceedings began.
Yes, the lawsuit kicked off in the Supreme Court of New South Wales in September 1978. Akhil Holdings sued the bank, Deauville, and Mr. Messara. The initial statement of claim laid out Akhil's basic case. It described the agreement, the direction to issue shares to the bank. It asserted the bank held the shares as nominee for and in trust for Akhil Holdings because Akhil had provided the consideration.
Standard trust claim.
Right. It then alleged that Mr. Messara had caused and procured the bank to transfer the shares to Deauville without Akhil's authority or knowledge, and it sought damages for conversion or breach of trust.
And an amended statement of claim followed.
It did. That document largely repeated the earlier points, but added more crucial detail. It asserted that Deauville, after receiving the shares, held them on trust for Akhil Holdings, and that Deauville's subsequent transfers to ED, EPR, and others were also without authority, consent, or knowledge, and were therefore in breach of trust.
Okay, implicating Deauville's actions too.
Yes, and it further alleged that Messara caused and procured both the bank and Deauville to execute these transfers. And importantly, it claimed that Messara's intention in doing this was to cause Deauville to transfer the shares in breach of trust, so as to deprive Akhil Holdings of all its right, title, and interest. That wording starts to point much more strongly towards dishonesty or fraud.
So how did the defendants, the bank, Deauville, and Messara, respond in their formal defenses?
Well, the bank appeared and submitted to the court's authority, but its defense was mainly just simple denials of Akhil's claims. Crucially, though, the bank also included a defense based on the statute of limitations, basically arguing Akhil had waited too long to sue.
The time limit defense.
Exactly. Deauville and Messara likewise denied any trust existed, denied conversion, and they also relied on the statute of limitations defense. Mr. Messara added his own special defense, that the 1977 settlement deed barred the claim against him personally.
Okay, multiple lines of defense. How did Akhil respond to those?
Now, here's a critical procedural detail that the High Court would later seize upon. Akhil filed formal replies to the defenses put up by Deauville and Messara. To counter their limitation defense, Akhil argued that the claim was based on a fraudulent breach of trust by a trustee, or that the defendants were privy or a party to the breach. This was vital because the Trustee Act had a special section 69(1), that said the usual time limits didn't apply to claims founded upon fraud or fraudulent breach of trust.
So alleging fraud to get around the time limit.
Precisely. Akhil also claimed in the reply that Messara's defense based on the settlement deed was invalid because it had been obtained by fraudulent misrepresentation. Now, while a copy of Akhil's amended reply to Messara's defense was served on the bank's solicitors on March 30, 1983, the sources explicitly note that Akhil filed no reply whatsoever to the bank's own defense, which also pleaded the statute of limitations. This seemingly small omission, the absence of a formal reply specifically addressing the bank's limitation defense, would have absolutely enormous consequences down the track.
Wow. Okay, so the stage was set for trial. The case goes before Justice Cohen in the Supreme Court of New South Wales. Defenses were filed by February 1986. The trial itself was completed that same month, and Justice Cohen delivered his judgment in July 1986. And evidence was presented, including Mr. Hari Akhil testifying personally about his side of the story, his understanding, his reliance on Messara.
Yes, Akhil gave evidence, and then there was a dramatic moment during the trial, the introduction of evidence from taped telephone conversations. One tape involved Mr. Akhil speaking with Mr. Trevor Gallagher, who was connected to Southland and Deauville, but also described as friendly with Akhil. Another tape was a conversation with Mr. Messara himself.
And the sources mention some confusing excerpts from these tapes, where Mr. Akhil is heard saying things like, I got $1 million, I gave $600,000 to Maurice, and this $600,000 Maurice got this for nothing. That sounds problematic for Akhil's case.
It certainly created problems at trial. Justice Cohen found that these tapes introduced a great deal of confusion. He explicitly stated he couldn't accept Mr. Akhil's explanation. Akhil tried to explain that when he said he gave shares to Maurice, he just meant they were put into the bank's name as nominee for Akhil Holdings purely on Messara's advice.
But the judge didn't buy it.
Justice Cohen didn't buy that explanation in light of the tapes. Based on that confusion, he concluded that the beneficial ownership of the shares remained unexplained and uncertain. And it's absolutely crucial to remember here, neither Mr. Messara nor Deauville gave any evidence at the trial. They didn't get in the witness box to present their side of the story. They weren't cross-examined about the transfers, their intentions, nothing.
Nothing from Messara or his company.
Right.
And what about the bank, the main defendant?
The sources state the bank itself did not attend the hearing at all. Despite having filed a defense that included that crucial statute of limitations plea, they simply weren't represented in court during the trial. This procedural fact would become a major point of contention on appeal.
So after hearing all this Akhil's testimony, the confusing tapes, no evidence from Messara or Deauville, the bank being a no-show, what was Justice Cohen's final verdict?
In July 1986, Justice Cohen dismissed Akhil's claim entirely, against all three defendants, the bank, Deauville, and Messara, his primary reason. He found that Akhil Holdings had failed to prove its beneficial ownership of the shares. He specifically cited the confusion created by the tapes as the reason why the ownership situation was just too unclear. At this stage, the dismissal wasn't explicitly based on the statute of limitations defense, but rather on this perceived fundamental failure by Akhil to prove their main claim of ownership.
Akhil Holdings obviously didn't accept this. They appealed Justice Cohen's decision straight to the Supreme Court of New South Wales Court of Appeal. The appeal was heard by a pretty distinguished bench, President Kirby, Justice Hope, and Justice Clark in August 1988, and they delivered their judgment in November 1988.
Yes, and the Court of Appeal undertook a really comprehensive review of the entire case. They looked at all the big issues. Could they even overturn Justice Cohen's factual findings about ownership? They decided they could, arguing his finding wasn't based on assessing Akhil's demeanor or credibility as a witness, but on the acceptability of his explanation for the tapes, which they felt they could reassess. They looked at the existence of a trust, whether a breach occurred, Messara's personal liability under Barnes v. Addy, the effect of that 1977 settlement deed, the application of limitation periods, especially that fraud exception, and critically, the legal effect of the bank just not showing up at the trial.
Okay, a full review. And how did the Court of Appeal rule on all these points? It sounds like they might have seen things differently.
They saw things very differently. They largely sided with Akhil Holdings, completely reversing Justice Cohen's decision. It was a dramatic turnaround.
Really? How so?
Okay, first on the trust. They found that even if you couldn't point to a perfectly documented express trust, a resulting trust in favor of Akhil Holdings was clearly established by the evidence.
A resulting trust. What's that based on?
It's a type of trust the law basically presumes exists in certain situations. Often where someone provides the money to buy property, but it ends up in someone else's name, and it's clear that second person wasn't meant to be the real owner. Here, their reasoning was compelling. Akhil provided the consideration, the mining rights for the shares. The bank itself had disclaimed beneficial interest, and those later transfers from the bank to Deauville and onwards for nominal or nil consideration strongly pointed to them just being held as nominees. The Court of Appeal called this an inescapable inference.
So they found Akhil did beneficially own the shares via a resulting trust. What about the breach?
Well, given that finding of a trust, the Court of Appeal concluded the bank's transfer of shares to Deauville and Deauville's subsequent transfers were clearly unauthorized breaches of that trust. Simple as that. Third, on Messara's liability. The Court of Appeal found Mr. Messara personally liable for knowingly assisting in these breaches. They applied that well-known legal principle from the case of Barnes v. Addy.
Right, the accessory liability rule.
Exactly. It holds someone liable if they receive trust property knowing it's in breach of trust, or if they assist a trustee's dishonest or fraudulent actions with enough knowledge. The Court of Appeal found Messara had the necessary knowledge of circumstances indicating a dishonest and fraudulent design, or at least enough red flags to put him on inquiry. They pointedly noted his conduct went far beyond just innocently failing to ask questions.
Okay, so Messara's liable too. What about that settlement deed defense he raised?
The Court of Appeal shot that down too. They held the general release in the 1977 settlement deed did not extinguish the claim against Messara regarding the Geneva shares. They applied established legal principles, like from Grant v. John Grant, which say general words of release in a deed are usually limited to the specific disputes the parties actually had in mind when they signed.
And Akhil didn't know about the transfers then.
Exactly. Akhil was still completely ignorant of the actual transfers and breaches when he signed the deed, while Messara knew the full picture but kept quiet about it. The Court of Appeal said it would be inequitable, basically, fundamentally unfair to let Messara hide behind that deed to escape liability under those circumstances.
Right, and the big one, the limitation period, the time limit defense.
This was a major win for Akhil in the Court of Appeal. They found that the usual 6-year time limit for bringing a claim did not apply here because of that proviso in Section 69 of the Trustee Act. Remember that proviso specifically excludes claims founded upon fraud or fraudulent breach of trust from the standard limitation period.
And the Court of Appeal found there was fraud here.
They concluded that the breaches of trust by the bank and Deauville were fraudulent breaches of trust in the specific legal sense meant by that proviso. And since Messara was found to be privy or party to this fraudulent breach, the limitation defense failed for him too. The source actually quotes their direct finding, quote, "In the relevant sense, this was a fraudulent breach of trust. Accordingly, the ordinary limitation period of 6 years was not available to the respondents."
Wow. So fraudulent breach means no time limit applies. What about the bank not showing up?
On the bank's non-appearance at trial, the Court of Appeal took a strong view. They held that because the bank chose not to attend the trial, it was effectively taken to have waived any objection it might have had. This included objections to issues litigated, maybe even issues raised later, or implied amendments to the claim that came up during the hearing. Basically, if you don't show up, you lose your right to complain later.
Goodness. So the Court of Appeal just systematically dismantled Justice Cohen's reasoning, didn't they? They found in favor of Akhil Holdings on pretty much every major point, found the resulting trust, found clear breaches, found Messara liable as an accessory, said the deed didn't protect him, said the limitation period didn't apply because the breaches were deemed fraudulent, and said the bank basically forfeited its objections by being a no-show. That's a massive victory for Akhil Holdings, right? Delivered November 1988, and the case got sent back to figure out damages.
That's exactly right. A powerful, comprehensive reversal by the Court of Appeal. But that victory, dramatic as it was, led directly to the final act of this incredibly long-running legal saga.
Which brings us to the very top. The highest court in Australia, the High Court, Banque Commerciale SA, which was by then in liquidation, appealed the Court of Appeal's decision. The High Court heard the case in March 1990. Chief Justice Mason presided, alongside Justices Brennan, Toohey, Gaudron, and Dawson, a full bench.
And this, right here, is where the case truly cements its status as a landmark authority. Perhaps even more for its pronouncements on the fundamental rules of procedure than for the nuances of trust law itself. The High Court focused intensely on several key procedural issues, and on these crucial points, they differed very, very sharply from the Court of Appeal.
Okay, so the final showdown. What were the central questions the High Court grappled with? What did they focus on?
The High Court really zeroed in on the absolute bedrock principles of how civil litigation works. Things like, how binding are the formal pleadings? The statement of claim, defense, reply. What exactly do you need to do when you allege something really serious like fraud, especially against a particular party? What's the actual legal effect when a defendant files a defense but then just doesn't show up for the trial? And how do you correctly interpret that Trustee Act proviso about fraud and the burden of proof? And the High Court's rulings on these procedural points were, well, absolutely decisive. They fundamentally altered the outcome, particularly for the bank. First, and this is the absolute linchpin of the majority's decision, pleadings and the allegation of fraud. The High Court stated in no uncertain terms that if you are making serious allegations, especially fraud or fraudulent breach of trust, you must plead them specifically and with particularity in your statement of claim or other appropriate pleading document.
Okay, be specific.
And crucially, you must plead them against the specific party you are accusing. They looked at Akhil's statement of claim against the bank and found it simply did not allege fraud or fraudulent breach of trust against the bank. The way the allegations were phrased in that document was consistent with maybe an innocent mistake or just a negligent breach of trust, not dishonesty.
So the wording wasn't strong enough against the bank.
Exactly. And the High Court held that simply serving Akhil's reply to Mr. Messara's defense, which did raise the idea of a fraudulent breach in the context of that Trustee Act time limit exception on the bank's solicitors, was absolutely not sufficient to properly plead fraud against the bank in the direct claim between Akhil and the bank. In that context, it was just a bare and unparticularized assertion. Therefore, the High Court ruled the Court of Appeal was simply not entitled to make a finding that the breaches by the bank were fraudulent breaches of trust for the purpose of defeating the bank's limitation defense, because that specific allegation had never been properly pleaded against the bank in Akhil's case against it.
So even if the evidence uncovered later might suggest something dishonest happened involving the bank, if Akhil didn't specifically write down the allegation of fraud or fraudulent breach with details against the bank in their initial complaint documents, the court just couldn't rely on it to help Akhil.
That's precisely it. The pleadings define the legal battlefield. If you don't raise the specific issue you need to win against a particular opponent, you can't rely on it later, even if evidence emerges that might seem to support it. You're bound by what you formally alleged. Second, and related to this, was the onus of proof issue under Section 69 of the Trustee Act. The High Court clarified that if a defendant pleads a limitation defense, like the bank did, and the plaintiff wants to rely on that special exception for fraud or fraudulent breach of trust to get around the time limit, the burden of proving that fraud exception rests squarely on the plaintiff.
Akhil had to prove the fraud to beat the time limit.
Yes. And since Akhil hadn't properly pleaded fraud against the bank in the first place, they logically couldn't discharge the onus of proving it against the bank. So they couldn't use the exception to bypass the bank's limitation defense. Third point, and this was a direct slapdown of the Court of Appeal's reasoning, was the effect of the bank's non-appearance at trial. The High Court decisively rejected the idea that the bank, by not turning up, had somehow waived its pleaded defenses.
So not showing up doesn't mean you give up your defense.
Not if you formally filed it. The High Court held that a defense that has been validly filed, like the bank's statute of limitations plea, remains operative and must be dealt with by the court, regardless of whether the party bothers to appear at the trial. Non-attendance does not automatically equal a withdrawal or a waiver of a properly pleaded defense. The bank was fully entitled to have the case against it decided based only on the issues as they were formally pleaded between Akhil and the bank. Akhil wasn't somehow relieved of its obligation to prove its case or overcome the defenses the bank had validly put on the record simply because the bank wasn't physically there. The bank's absence didn't put Akhil in a better position regarding the pleaded issue.
Wow. So essentially, the bank could file its defense, including that crucial time limit argument, then basically sit back, not show up for years of trial proceedings, and still potentially win the entire case against it based purely on the initial paperwork if the other side messed up their paperwork, specifically on pleading fraud against the bank.
In essence, yes, for the claim against the bank. Provided the defendant has properly pleaded a defense, like the statute of limitations, the plaintiff still carries the full burden of proving their case and overcoming that specific defense based only on the issues defined in the formal pleadings between those two particular parties. The High Court really emphasized that litigation has to be conducted according to clear, established rules, and parties are fundamentally bound by the case they choose to plead, for better or worse. So based on these critical procedural findings, the majority of the High Court Chief Justice Mason, Justices Brennan, Toohey, and Gowdrum, they concluded that because fraud was not properly pleaded against the bank, the proviso in Section 69 of the Trustee Act simply wasn't engaged in the claim against the bank. Therefore, the bank's statute of limitations defense succeeded. End of story for the bank.
Just like that.
Just like that. The High Court allowed the bank's appeal. They set aside the Court of Appeals judgment against the bank, and they restored the original trial judge's dismissal of the claim specifically against the bank. It's worth noting, Justice Dawson dissented on the final outcome concerning the bank, though he actually agreed with the majority on many of the underlying procedural principles about pleading fraud.
That is a truly striking, almost harsh example of how absolutely critical the precise details of legal procedure are, especially when serious allegations like fraud or dishonesty are in the mix. A failure to, dot the I's and cross the T's in those initial legal documents, particularly regarding who you are alleging fraud against, can completely derail your entire claim against that party, even if the underlying facts seem really compelling.
It is indeed. And while the High Court's judgment primarily dealt with the bank's successful appeal and the specific procedural points that ultimately protected it from liability in this case, their crystal clear pronouncements on the mandatory requirements for pleading fraud and the real effect of a defendant's non-appearance laid down fundamental rules for all future litigation in Australia. The claim against the bank was ultimately dismissed purely due to these specific procedural deficiencies in how the case, particularly that crucial element of fraud needed to defeat the limitation defense, was framed against that particular defendant.
So looking back at this entire incredibly complex, multi-layered saga, what are the big lessons here? What does this mean for someone trying to understand how the legal system actually functions, especially when the stakes are so high?
Well, this case, Akhil Holdings, remains an absolute cornerstone of civil procedure teaching for several really key reasons. Firstly, pleadings are the foundation. It's just a stark reminder that your statement of claim, your defense, your reply, they aren't just bits of paper. They are the documents that legally define the entire scope of the issues in dispute. You absolutely must plead your case clearly and comprehensively from the start.
Get it right first time.
Exactly. Secondly, allegations of serious wrongdoing require specificity. If you're alleging fraud, dishonesty, or fraudulent breach of trust, the heavy stuff, you must plead the specific conduct you complain of with sufficient detail, and you must direct that allegation clearly against the specific party you are accusing. Vague hints or implied allegations just aren't enough, and critically, you can't rely on what you pleaded against defendant A to somehow count as a proper allegation against defendant B.
Got it. Each defendant needs their own specific accusation.
Precisely. Thirdly, the onus is on you to prove exceptions. If a defendant raises a valid defense, like the statute of limitations, and you want to rely on some special legal exception to get around that defense, like the fraud proviso in the Trustee Act, the burden is entirely on you, the plaintiff, to plead and then prove the facts necessary to trigger that exception. And fourthly, a filed defense stands its ground. A defendant who files a defense is perfectly entitled to rely on every single point raised in it, even if they decide not to actively participate in the trial later on. Their absence does not magically strip them of their pleaded defenses. The plaintiff still has to prove their case and overcome those specific defenses based on the issues as they were formally defined in the paperwork.
It really highlights that constant tension you see in law, doesn't it? Between wanting to achieve what feels like substantive justice based on the underlying facts, figuring out who really had the right to those shares versus the absolute necessity of procedural fairness, ensuring every party knows exactly the case they have to meet, and making sure the whole legal process is conducted according to strict, predictable rules.
Absolutely.
And in this instance, it seems the High Court clearly prioritized those procedural rules. They concluded that Akhil's failure to properly frame its case against the bank, specifically on that crucial element of fraud needed to bypass the limitation period, was fatal to that particular part of the claim, regardless of the underlying merits.
It's a powerful, perhaps even sobering example of how the rules of the game in the courtroom can sometimes override what might seem like the apparent strengths of the underlying facts. Procedure matters. Hugely.
This deep dive into Akhil Holdings v. Banque Commerciale truly underscores how profoundly the seemingly technical details of legal procedure matter. I mean, a dramatic, decades-long story involving immense value, a completely broken trust, complex international arrangements, secret transfers, litigation bouncing between multiple levels of court, and it ultimately turned not just on the facts of what actually happened, but on the precise words used, or maybe more importantly not used, in legal documents filed years before the final judgment.
It serves as such a powerful reminder, doesn't it? For anyone navigating the legal system, that understanding and scrupulously following the rules of procedure is just as essential, maybe sometimes even more essential, than simply having a strong factual case. Knowing the exact case you need to prove and ensuring your opponent knows the exact case they need to defend against is absolutely fundamental to the fairness and ultimately the effectiveness of the legal process.
And it leaves you considering, well, what ultimately became of those Geneva shares after the High Court's decision regarding the bank, and maybe more broadly. What are the implications here for individuals placing significant trust in advisors for complex financial structures, especially those that span international borders and involve potentially sensitive arrangements like nominee holdings?
That really raises an important practical question, I think, for anyone involved in such arrangements today. Beyond just ensuring the underlying agreements themselves are solid, how do you also ensure you are procedurally prepared to protect your interests years, maybe even decades, down the line if disputes arise? Particularly when you're relying heavily on professional advice, dealing with complex international structures, and facing the incredibly stringent requirements of litigation procedure if things go wrong.
Yeah, a lot to reflect on there, indeed. Thanks for joining us for this deep dive into a truly fascinating case. We hope you, listening, gain some valuable insights.